to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody. Welcome to the show. Today, we're talking about the ABCs of commercial PSAs. That would be purchase sale agreements. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on YouTube, Facebook, and X. You can find us at the handle @InRem Podcast. That's @InRem Podcast. Also, you can download the podcast and hear it in its audio format. You can do that on Apple, Spotify, or any of the major podcast platforms. With that, we're going to turn it over to Sean, who has our legal update.
Thank you, Andy. So my legal update today is, what is a promissory note and why is it used? Now, we've been doing the show for a long time, and I have never addressed promissory notes. And I think part of the reason is I thought it was, kind of basic, but as the more and more we work with real estate investors and others, the more we're coming to a realization that maybe a promissory note is not fully understood or appreciated as far as how it works, how it operates, what it is. So basically, a promissory note is a promise to pay money to somebody else, or a promise of performance to somebody else. So you can have a promissory note that basically says, I promise to perform in a certain way. I promise to, for example, in a subject to transaction, I promise to pay your lender on your behalf. So it's a promise of performance, but generally it's a promise of performance in the paying or repaying of money. So if you have a lender that loans money to a borrower, the borrower then executes a promissory note back to the lender that basically says, look, lender, I promise to pay you. And the borrower delivers the original of the note to the lender. And actually, promissory notes in the legal world, the commercial world, act very similar to checks. You generally need to hold as the lender, and sometimes they're called the holder because they actually hold the original of the promissory note. And it's that original note that is then presented for payment, or if a lawsuit's filed, it's that original note that, is shown to the court that entitles the lender to be paid from the borrower. Similar to a check, you can actually take a promissory note and endorse it over to somebody else. So you could take the back of it and you can say, I, the holder, hereby endorse and deliver and make this promissory note going forward payable to, and you list the person that you're gonna hand over the promissory note to. So promissory notes can be bought and sold on the open market, basically. And so you could be the original holder, the lender, and you decide, I don't want this anymore. I don't want the monthly payments. I just want to be bought out. And you can find somebody that's gonna, buy you out. Now, in order to sell or convey or transfer a promissory note, and for somebody to buy a promissory note, they generally are going to want to see a servicer in place. And what a servicer is the middleman between the borrower and the lender, whereby the borrower makes the payments to the servicer takes off their fees and then passes that money on to the lender. But the servicer makes a full accounting of every payment that's come in, the interest that's accrued, and any charges, late fees, any other amounts that are owed under the promissory note. The servicer keeps a record and accounting of that. And so when you go and want to sell your promissory note, the servicer then has a nice complete record that they can transfer over to whoever acquires or is purchasing the promissory note, so that they fully know and appreciate exactly what's due, when it's due, and they know that they're taking the promissory note in a certain condition. Versus, let's say that you have the borrower making payments directly to you as the lender. How does a purchaser know when you send the note over to them? How does the purchaser know what payments have been made, other than what you verify or you state? But you could misstate, you can miscalculate, or you can even commit fraud and misrepresent the amounts that are owed. And so a purchaser doesn't have that certain level of verification. Maybe they'll buy it, but they're probably going to ask for a steeper discount in doing so, or they may not buy it at all, because there's just no way of fully appreciating and reconciling the numbers. Frankly, even the borrower could lie and claim amounts that are different than maybe what the lender is showing, and then it's the borrower's word against the lender, and it's a real rough spot for you as the purchaser to be in. So basically, kind of getting down to the nitty-gritty, a promissory note is a promise to pay money or to perform some obligation as stated in the note, and it is a negotiable instrument that can be bought and sold on the open market. And the reason why it is used is basically to evidence a loan, and evidence the obligation to repay a loan is generally when it's used.
All right. Thank you for the legal update. With that, we're going to talk about a couple updates that we have here at the NREM podcast. The Creative Finance Collective, 3 p.m. every Tuesday, Arizona time. What is the Creative Finance Collective? If you've watched, you've got an idea about what that is. But if you're coming new to the show and seeing what that's like, the Creative Finance Collective is really an opportunity for professionals in the space of creative finance. So mainly lawyers, attorneys that get together from a variety of locations, jurisdictions, and they're in the space of creative finance, and they're approaching it from different legal perspectives, depending on what state that they're coming from. And we work through issues that we're seeing and work to find ways to improve our own forms, our own practice. But what we do throughout the entire hour is make ourselves available to you, the listener. So if you've got questions about creative finance, could be anything, questions about or questions that tangentially relate to creative finance, and you're just wondering how the process works, there is no too complex or too basic question. We're there to kind of sift through it and discuss and go through it. So if you want to interact with us and talk creative finance, we're there for the entire hour. We'll be doing that today at 3 p.m. Make sure to join us. It's a good time. Also, today, as we're talking about commercial purchase and sale agreements, we are taking questions. So in the final 15 minutes of the show, we like to answer those questions as you have them, but don't wait until the final 15 minutes. Bring them to us. We're monitoring the chat. You can place the questions in the chat. We'll review those, and we will address as many questions as we have and go through those as we get them. With that, let's get into our topic today. Again, we're talking about the ABCs of commercial PSAs. And with us to discuss that is our friend Michael Gross from the law offices of Michael Gross. Michael, how are you?
Okay, how are you doing?
We're doing well. So good to see you and have you again. For the listeners, I know you've been with us before, Michael, but for those who aren't familiar with you or are hearing from you for the first time, why don't you tell us a little bit about you and your practice and what you focus on?
Well, I'm an attorney in practice in Maryland and Washington, D.C. I focus primarily on working with investors in all aspects of dealing in investor real estate, commercial, residential. I draft contracts, I do real estate settlements, and I'm also, and part of my practice is being counsel to a local real estate settlement company. So I get a chance to see transactional real estate from all aspects.
Yeah, and I know the last time we had you on with us, we talked in detail about creative finance, and you had a lot to say about that. That's definitely an area that you've had as a practice area, and we'd encourage folks to go check out that episode. But today we're talking about commercial real estate and structuring the purchase and sale agreement as it applies in the commercial context. Why don't we just start with the basics here? There's certain things that we assume are common knowledge, but they may not be common knowledge amongst non-attorneys or investors in the space. So let's talk about what are we talking about when we talk about commercial real estate? I think most people agree, well, we're not talking about homes, but what are the other types of kind of commercial space that we're typically dealing with, or that you might be typically dealing with on any particular transaction when it comes to commercial?
I was thinking about this, and the best definition I can come up with reminds me really of a case years ago the Supreme Court had. Potter Stewart was the judge. It was a case involving obscenity, and the court was trying to define what obscenity is. And after pages and pages of historical analysis and legal analysis, they came down with a conclusion which everybody basically categorized as, you know it when you see it. And that's the best definition I can come up with for a commercial transaction. You know it when you see it, because it depends on what the issues are that are involved. The more complex the transaction, the more issues that are involved, the more likely you are to class it more on the commercial side than the simple residential side. So for example, if you're buying a $5 million house, you could probably just buy that in a simple residential contract. If you're buying a $5 million shopping center, on the other hand, you've got a lot of other issues involved in it. And that's where the idea of it being commercial, of you're requiring a more complex contract and analysis comes in. Another way of looking at it is when you're buying commercial real estate, you're actually buying two things. You're buying the real estate on the one hand, but you're really buying an operating business along with it. So the shopping center itself, the land has a certain value, and you do a due diligence on that. But then you've also got to do a secondary due diligence on the business of running the shopping center and dealing with the tenants and the common area maintenance and other costs, and advertising the center itself as an entity. So it's its own separate business entity. When you start running into issues like that, that's when I think you start calling the transaction commercial rather than simply a residential or retail, you might say.
Sure. And I like the way that you say that. You know it when you see it. We drive down the road every day, every shopping center we go to, every four-way stop that we drive through, we see it. We know it when we see it. But what's interesting on the legal side of this, when we think about residential, for instance, it's just this one big category. But when you move to commercial, and I think you really kind of mentioned this in describing it, every particular area of commercial is unique and almost its own niche. Each one of them has its own considerations that you care about. Oftentimes, real estate's a big part of it, and the business side's a part of it. But how those things work together, office space versus retail, shopping center versus industrial, all those are pretty unique to the particular niche area, right?
Sure, everything, people complain about the laws that there's no clean answer. It all depends on what the facts are of the particular case. And that's the way it is really when you're buying anything that isn't straight retail, find a house, figure out the financing, go to closing. Anytime you've got the secondary issues of managing the investment itself, you've got a commercial transaction. I'm working on one right now where somebody's buying 12 residential duplexes. Each one of them on its own would be a residential purchase. When you bring them all together, since this person is getting into this town for the first time, they now have got to figure out the whole management structure for what effectively is a 24-unit apartment building just broken up as a bunch of houses down a street. Bears commercial analysis rather than simple residential analysis.
Michael, how would you classify vacant land? Because obviously, you don't have an operating business there, but unlike residential, vacant land has a tendency to have other issues. What are your thoughts on vacant land? How would you classify it? And, what are some things that separate that from residential, typical commercial with, office space, tenants, that type of thing?
I'm reminded of my father, who once said that only an optimist buys vacant land. But the analysis there is, what am I going to do with it, and what can I do with it? What's allowed by zoning? What's allowed by the neighborhood? What other businesses are there? And so it has that analysis to it. It doesn't have a lot of the typical issues of dealing with tenants and whatever, because it's vacant. But unless you're the kind of person who simply says, I'm going to buy this land and just throw it into the inventory and wait for progress to roll over me, there is that level of analysis that that is commercial to it, but it's more amorphous, really, because you really, in many cases, don't have any idea what you're doing with it, unless you happen to know that the highway is coming along and the interchange is going to be in your front yard. Then, of course, you're in great shape.
What about environmental concerns with vacant land?
Yeah. If the land has been used for something else, there was a gas station on it that was torn down 10 years ago. You're going to have those concerns. You're going to have to do environmentals. But I suppose that's part of running the due diligence on the land itself. If it's a farm somewhere and the only environmental concerns is cow dung, you're okay. But yeah, you do. We had a deal in property in the small town near us here, which had a chunk of land that had been vacant for, I'd say, 10, 15 years. And it was only the investors from their area who knew that it had previously been a hardware store that had they used to sell a lot of kerosene and other gasoline products. And so the locals knew that this was an environmental concern. Anybody coming in from elsewhere probably wouldn't have. So you've got to do some digging there too. Absolutely.
Michael, let's get into some of the big differences. If you're coming into this trying to structure a purchase and sale agreement, some of the biggest differences, especially if you're coming from the residential side to the commercial side. One big difference is the LOI, or the letter of intent. Why don't you explain that process and how that's unique to the commercial context?
A letter of intent is probably the simple way of thinking about the whole letter of intent contract process is rather like getting married. A letter of intent is an invitation to date, is really all it is. It's a letter which simply says, I like your property and I would be willing to buy it on these general terms. This is the rough price, and I need 60 days for a due diligence, and I want to have a contingency for financing. And if you agree that you're willing to negotiate with me about these terms, sign here, and I'll have my lawyer start drafting documents. All you're doing at that point is dating. You're not even going steady. I mean, you're just trying to get to understand each other. At that point, one side or the other, usually it's the buyer's side, drafts a contract. And in a commercial context, it could be somewhat lengthy based on the issues that are involved with the particular property, whether it's an office building, a shopping center, vacant land, whatever it happens to be. Usually there's some kinds of contingencies involved in the drafting of it. You may want to do a phase one environmental. You may want to spend 60 or 90 days looking over the leases or looking over the other issues. You want to inspect the property itself. And so you draft a contract with the various contingencies in it. That contract gets signed, and at that point, you're going steady. You're engaged, you might say, and you're not going to break this thing up unless you find a reason to during your due diligence. Then once the contingencies are taken care of, if you decide you're going forward, that's when you get married, and you've got to perform under the contract. But a letter of intent is merely an invitation to dance.
And maybe that's the cultural problem we face, that dating needs to incorporate the letter of intent. Maybe we could bring more people together by just following a commercial transaction with the letter of intent. I like that. Go ahead, Sean.
So, Michael, I love this dating example because you can really see it through the process. So back to the dating, you hear people say, "Oh, we're exclusive now." Right? Oh, okay. So talk to us about the letter of intent, and does that create any level of, exclusiveness as far as, ability to, can the seller still negotiate with the other, with other parties? Can they still, entertain offers, or are they exclusive to the buyer after the letter of intent?
It depends on what the letter of intent says. In virtually every letter of intent, the last paragraph says, this is not a contract. This is a expression of our desire to make a contract, which will happen sometime in the future. But you can also have a provision in it which says that we agree, and this is contractual, that neither one of us, well, it's the seller usually. The seller is not going to go out and try to sell this property to someone else while the preparation of a contract is pending. It can be open-ended, or it could say for 30 days, for 60 days, whatever it is. That portion can be viewed as contractual, and the seller would be barred from going out and dating somebody else. If you don't put that in there, then it's a rush to get the contract signed as quickly as you can, so that at that point you're engaged.
So let's talk about price. Seems like a simple thing. It's just numbers, whether we're talking about a residential purchase contract or a commercial contract, right? It's just numbers behind a dollar sign. But I think what's missed is there's a lot more that goes into how that number is determined in a commercial contract. And you kind of alluded to some of this, that a lot of times we're not just talking about real estate. We're also talking about businesses that sit on the real estate. It could be multiple factors. How do you see that difference play out?
Well, the price on any sort of commercial property is, in the beginning, when you're doing the letter of intent, is really more of a suggestion. You should make an offer, use a number that's reasonable, but based on the information you get during the due diligence process, that number could change. I talked about the client who was buying 12 duplexes. It turned out that the financial information that the real estate agent had given wasn't accurate. The rents were accurate, but the rents weren't being collected. So now the cash flow on the property is no longer what everyone thought it was. The buyer is now going to have to go and either fight with these tenants to get them to pay up, or go to court, evict them, whatever. And so the cash flow on the property changed, and the price changed during the due diligence process. They bought the property, but the seller came to realize that it just wasn't worth what the original price was. When you're negotiating a contract, everything is negotiable. there's nothing that's, you may say up front, that's set in stone until the time comes when all conditions are resolved and things are final. Particularly with commercial property, there are just so many variables. During the pendency of the contract, if the city comes in and decides it's going to widen the street in front of you and take 20 feet off your parking lot, that's going to take value away from the property. Commercial contracts will often have condemnation preceding paragraphs in them, but in any event, you still have an issue about what the property is worth at the end of it. I would never encourage anybody to make an offer on property on the theory that this number isn't real and I'm going to change it later, but it does sometimes happen.
Michael, talk to us about earnest money deposits on the commercial side. On residential, they tend to be, on the kind of the smaller side, 1,000, 1,500, 2,500. And it also depends on the purchase price, but there's in a lot of ways, no rhyme or reason. They just kind of pick a number. On commercial, is there any, kind of formula that's used to determine the amount of earnest money deposits? And also, is it always just one earnest money deposit, or sometimes, do you see multiple earnest money deposits?
The number for the earnest money deposit is as negotiable as anything else. Any earnest money deposit should be enough money to convince the other side that you're serious, but it should never be so much that if you lose it, you won't eat tomorrow. It's just a way of sort of putting your money where your mouth is initially. And it's not uncommon to have situations where you will have multiple deposits as time goes by. For example, in the beginning, when you're just writing the contract, but before any due diligence is done, you might put down a deposit of some amount. But then at the end of the due diligence period, or a portion of the due diligence period, if you plan to go further, you may put down more money. Or if you need extra time, you may make an addendum to the contract, say, I need an extra 30, 60 days, and I'll put some money down just to show you I'm real. At some point, some of that money could be irrevocable. And the seller would get it whether you perform or not under the contract or not. Again, this is all negotiable. And the deposit is just there to make the seller feel that your heart's in the right place and that you're going to do it. You could put together a contract with no deposit at all, but it's rare.
Right.
Michael, one of the big differentiators, I think, in the residential and the commercial transaction is the due diligence period and what happens there. Of course, in a residential transaction, there's inspections and the things we're all having come to be used to, having purchased houses and such. But in the commercial transaction, there's so much more that goes into that and is planned for and has to be planned for in the contract itself. Let's kind of start with the first of those. And one of, I think, a big difference is the length of time for due diligence. What is a common length of time? I know this could vary depending on the type of transaction, but what's a typical due diligence length of time you would see built into a PSA?
That's sort of asking how high is up, really. It depends on the transaction itself.
Sure.
All right, let's go back to my 24 units. It might take 30, 35, 40 days to go through the paperwork for that. And so your due diligence period may be that period of time. If you're buying a shopping center with, 40 stores and a little bit of office commercial on the side, it might take you 60 or 90 days to figure out whether the entire shopping center itself is a worthwhile investment. And then a part of it is really going to be involved with how much help you as a buyer have. If you've got 4 accountants and 3 lawyers and 2 property managers on staff to review stuff for you, it may go significantly faster than if you're sitting in your basement trying to do it yourself. I don't recommend sitting in your basement trying to do it yourself. The cheapest commodity in the world really is somebody else's brains. So you should hire experts if you've got expert analysis needed. I wish I could give you an answer, but there really isn't an answer. It's going to depend on how much there is there.
Yeah, and I mean, I think that is the answer, right? It all depends. And when I think about transactions that I've been a part of, the ones that involved what I would have considered short due diligence period, 45 days, let's say, those are usually transactions where a lot of due diligence happened before they even got to the lawyers. They were spending a bunch of time in the LOI. They had given maybe advanced access to financials of the company. And they had started a lot of that process, and they only needed to build out so much more. But to your point, it really is a fact-sensitive question. And I in my estimation from the lawyer's side of things, the longer it can be, the better, right? I don't know why we want to. I know why the investors want to rush to close this thing because there's money on the line and everything else. But from the lawyer's perspective, man, the more time I have with that, the better.
Well, I'm sure you never want to negotiate a contract under the gun. The worst time in the world to negotiate anything is when the other side is looking at you while you read the papers. The psychological pressure there is too much. But and then the other side of it is if somebody insists that something has to be done fast, or the deal is not going to happen if you can't meet their super quick timeline, to me, that's a red flag.
Yeah.
Because they don't want you to know what it is that needs to be known. That kind of a deal is best walked away from. And you're right, though, in some circumstances, when you're looking at an investment, a lot of the paperwork will be available in advance. And if it is, so much the better. But if you get to see it in advance, effectively, you're just doing your due diligence in advance. And so the net time of due diligence remains about the same.
Yeah, that's right.
Michael, one of the, what I see differences in the commercial transaction as opposed to the residential is how title review and title objections are treated. In the residential context, I can count on the number of hands where I've seen ever a letter, an email, or any objection made to the commitment. But on commercial, I've never handled and seen a commercial transaction where there weren't title objections and cleaning up of the commitment. Sometimes there's endorsements that are required, and issued by the title company. Talk to us about title review on commercial as opposed to residential.
You're right about that. There's very little objection to title in residential cases because in most of those cases, the situation is really pretty cut and dried, and there aren't a lot of variables. The average property is going to have easements for utilities. There may be a homeowners association with covenants that apply to it. And those are really about it. None of them is anything that can be negotiated away or changed. Yes, there's an easement across your property for an electric line, but you want the electricity. You're not going to say no. The homeowners association, if you buy your way into that little mini democracy, well, you're stuck with it. You can't pick and choose whether the covenant that says no basketball hoops in the front yard is going to apply to you. You're just, stuck with the community's rules. On the commercial side, though, it's a little different, largely on account of the lender. The lenders want certain very specific coverages in title insurance that very often you won't see in residential. So for example, they want to know that the property abuts a public highway. There's an endorsement for that. Or that the 4 parcels that make up the property are in fact contiguous and there is no gap between them. And so there's an endorsement for that. The legal description is the same as the actual survey of the property. There are no discrepancies there. There's an endorsement for that. All of these are check the box things for the lender because they don't want to make a loan and wind up foreclosing on a mess.
Mm-hmm.
And so very often they're the ones who are going to control that process. The buyer does look at things because it may very well affect the purchase. So if they look at the title work and they find out that the back third of the property is within a conservation easement, and they're not going to be able to extend the parking lot back there to add the 4 extra stores, well, that's going to change the purchase analysis. So those kinds of things tend to be issues on commercial cases. You'd like to think that the issues would have arisen during the rest of the due diligence when they got the other information, but sometimes it doesn't come up until someone looks at the title report and realizes that there's an easement to benefit the neighbor's property and you can't build on it, we'll say. That can affect the value of the investment.
So you mentioned survey, which once again is a pretty significant difference between residential and commercial. I don't know that, except to the extent that there's been boundary disputes, I don't remember seeing surveys on residential real estate, but in pretty much every commercial transaction I've been involved in, a survey is either obtained from the owner and it's recent enough, or the buyer has to go and provide a survey. So talk to us. What is the survey? What is a survey? And why is it important on commercial and as opposed to residential?
In general, a survey is a top-down view of the property from the bird's eye or the drone's eye that lays out the boundaries of the property and the location of the improvements on the boundaries on the property relative to those boundaries. This is important for the bank because they want to be sure that this house or this property they're foreclosing on doesn't have any boundary issues. That the house really is on the land and not over the line. That the parking lot that's part of the value of this business is entirely owned by the business. It's on its own side of the line, not on the neighbor's side. Surveys are much more common. Oh, and then there is something, a very much more detailed survey, an ALTA survey, which the lenders may want, which actually discloses every single item that appears on the land down to and including the pots in the sidewalk where the water meters are located. It's that detailed because if the lender's going out of pocket for a few million, they want to know everything they can about the property in the same way that they want to know about the buyer's credit and everything else. You don't often get surveys on residential property because if you're in a subdivision, air quotes, everybody knows where the boundaries are. On the other hand, I had a wonderful case where the buyer got a real good deal on this property and he was dying to buy it until he got a survey and found out that the back third of the property was actually over the line in the public alley. Did a little more digging, come to find out there were no building permits, whatever, and needless to say, he didn't buy the house. But in residential properties, lenders will often require what's called a house location drawing, which isn't really a true survey. It's the surveyor's best guesstimate without really doing any hard work as to where the boundaries are. And you'll even see that on a house location drawing, things are represented as being a certain distance plus minus. That lets the parties sleep a little better, but it's not a true survey. And if you're buying a residential property and the seller says it goes all the way back past the tree to that big bush back there, if that's critical for you, you may want to actually get a survey, because you may come to find out that the property doesn't go all the way back to the big green bush. I had another situation where an entire subdivision was laid out 10 feet the wrong way. The builders had built the houses, and the first one they laid out was wrong, and everything down the street was 10 feet the wrong way.
Yeah, we have those issues here in Phoenix. I mean, these subdivisions are fast and furious, and these contractors just go out there and start building. And so pretty much, I would say every subdivision, the masonry walls are not on the property line, but it's just the nature of it. And there's at least one title company in town that I know of that's been using the GIS maps, which those lines aren't even 100% accurate, but they've been, doing the overhead and seeing, where those walls sit in relation to the lines shown on the assessor's GIS map. And then they're putting in exceptions for that. But, you're talking 2 or 3 feet here or there, and it's not really a major issue, but it is, when you buy property, you just never know if that masonry wall is exactly on the property line or not. And sometimes, I'm guessing back on the East Coast, where contractors really weren't installing fences. A lot of times it's just the property owners going out there and installing their own, wood picket fences and other things. I'm guessing a lot of those, when you get a survey, you're going to find, it's not quite on the property line.
Well, the interesting thing about it is that title insurance, this is something everybody should know, does not insure matters of survey. A title insurance policy only says, we, the insurance company, guarantee that you own lot 12 in block 6, in such and such a subdivision, wherever that happens to be on the ground. So, unless you go and get a survey and buy specific coverage for it, a title insurance policy will not protect you as to matters of survey.
Right.
Around here, you can put up a fence anywhere you want to. There's no law that says you can't run a fence through the middle of your property. It doesn't have to be on a boundary line. People come to understand where the boundaries are over the course of time, because that's where the bushes have been, and it's gotten overgrown and whatever. But unless you actually run a true and accurate survey, you're not going to know where your boundaries are. Now, in some of the urban areas, you have party walls, which are by definition online. Those things, are online. Because it goes back to the original subdivision and building. But anything else, and you sometimes do get variances, particularly when you've got, at least around here, houses where the eaves of the house overhang the neighboring townhouse. You'll have covenants in the land records which say, we know this stuff overhangs and is on your side, but everybody grants everyone else an easement for that purpose. But if you truly want to know what you own, you need a true and accurate boundary survey with iron pipes pounded in at the corners.
Yeah, that's exactly right. And so to break down what you were saying as far as not covering a survey, so basically the title company says, hey, we're not going to insure anything that a survey would reveal as being a problem to the property. So that's the exception, right? Is the survey, what we call the survey exception, which basically says, hey, if you could see it, if you went and got a survey and you could see the encroachment or you could see the problem on your property, tough luck, you didn't get the survey and we're not covering it. So it's on you to go and get that survey. And if you don't, and that exception appears in residential title policies, and just know that, hey, they're not generally, these title companies are not insuring encroachments or other issues that a survey could reveal.
Right. Otherwise referred to in a way as defects suffered or assumed. So if you're if you're buying a farm, whether you get a survey or not, and you can see evidence of a little roadway that runs across the farm from one side to the other, from one neighbor to the other, and may not be an easement, there may not be anything there, but you don't raise it. You can't come back later when the neighbor drives his truck across your property and claim that your title insurance should protect you against this roadway. You saw it, you didn't do anything about it, you've assumed it. And that's one of the reasons, by the way, why lenders in commercial situations, to get back to where we started, want surveys, because they want to know that there's not going to be anything out there that's going to cause a problem later, when, of course, in their point of view, they foreclosed on the property and they're now stuck with it.
Right. Michael, one of the big pieces to commercial properties, I think, is that we're almost always talking about tenants being involved, whether it's a shopping center, whether it's multifamily, you name it. Usually you've got the property owner leasing out to tenants in some fashion. It could be one, it could be many, but a big part of the due diligence period and carving out an appropriate amount of time for it is really this lease review and obtaining estoppel certificates, this period of time in due diligence. Why don't you talk to us about that, what that typically looks like?
An estoppel letter from a tenant is a letter which identifies the lease, states whether or not the payments on it are current, and the average one better show the payments are current or there's an issue.
That might go back to when they decide to change the purchase price.
Yeah, might decide to change it, yeah. And that neither the landlord nor the tenant has any reasons to object to the lease, and that it's in full force and effect and not subject to any problems. The lenders want these because they want to know that the cash flow that they're being told about is real. Most commercial leases actually have a provision in them which say, you, the tenant, will give an estoppel certificate if I ask for it. And it also says, and if you won't, when I ask for it, you appoint me as your attorney, in fact, to fill it out for you. That's how serious these things are taken. If you're making any kind of substantial purchase like that, you probably do want to get estoppel letters from your tenants, because you don't want them coming back later and talking about that side deal I had with the old landlord where I didn't have to pay for 6 months. That's what the estoppel letters in part do to prevent.
Talk to us of the importance of attorney review of the leases. I think a lot of clients are like, well, why does my attorney need to sit down at X amount of dollars and review the lease? I know in my commercial work, I've had a number of issues come up that upon reviewing the lease, we realized, oh, we have problems. Talk to us about some things that you might find in a lease that you look at and you're like, whoa, wait a minute. One common example that has come up that it only resulted from my review of the lease that we discovered it was a buried right of first refusal, in that lease. So talk to us a little bit about the things that you might find in a lease that have to be dealt with and why you should have an attorney review it.
What you're looking for in most cases is a sweetheart deal of some kind, like right of first refusal. Lease rent, getting old, forgetting the word, the ability not to pay rent for several months for whatever reason.
Right.
Rent abatement, thank you very
Yes.
much.
Mhm.
Provisions like that, normally you'll only find rent abatement, what have you, in the beginning of the lease while there's a build out, we'll say, going on with the tenant.
Mhm.
But yeah, you do worry about things that might be in there that you won't know about. In some instances, it's not really a problem if you've got, we'll say, well, a residential building where the management company has a standard form of lease that they like to use, and you can tell instantly if something's been changed because it'll be whited out, crossed out. There's another page added,
Right.
and you'll get that. It's more difficult when you've got longer leases that are individually negotiated. There's a balance point, I can't argue with it, between having every single word reviewed by counsel and just letting it go and saying everything's fine. At least you've got to look over the paragraph headings and see what's
Right.
there. It's, I suppose it's partly a function as well of the property itself.
Mhm.
If it's something that is subject to specialty handling, like you said, a first right of refusal, yeah, you've got to be concerned about that. It would be rare in a situation where you've got multiple tenants, but where you've got a single tenant,
Mhm.
or particularly an anchor tenant,
Mm.
then you do definitely want to look at those things. And when you're dealing with a shopping center with one or two anchor tenants, you really want to know what those leases say. Because if you lose your anchor tenant in a shopping center, the whole thing could crater.
Right, and you mentioned sweetheart deals, and so a lot of times we think in commercial spaces, office space, retail, whatever, the landlord and their attorneys write the lease. You have little negotiating power as the tenant. You might have a few things that you can change here or there, but that's it, and it's a landlord-friendly lease. But what people don't realize is, you mentioned anchor tenants. Anchor tenants use their own lease, and they insist on it. You have a big corporate entity that's going to anchor that space, and they're very valuable to the landlord, and the tenant knows it. And their attorneys, the tenant's attorneys, have put together the lease with sweetheart provisions in there to protect that anchor tenant. And so it's critical to look at those leases and make sure that everything is covered. Because if it's a right of first refusal and the seller has not notified that tenant of the purchase contract and let the time go by, like, you can't close. You have to wait now. So, talk to us about, what you would be looking for in an anchor tenant lease, and maybe some of those sweetheart provisions.
Maybe like an exclusivity provision,
Right.
because what these investors do is they have people and tenants that they decide they want to bring in ahead of the deal. It's like, oh, I know, Vinny's Pizza Shop wants to do a second location. He's a friend of mine. I can bring him into the struggling center. But you get into the due diligence, and there's a Domino's Pizza there, and of course, there's an exclusivity provision that says there are not going to be any other pizza or Italian shops in the center. I would think things like that potentially.
Yeah, that's exactly right. To say what could be sweetheart deals is, again, it's sort of how high is up. But exclusivity is definitely one of them. Sometimes the exclusivity would be limited. There can't be anything within so and so many 100 feet of me. So if you've got a huge shopping center with multiple buildings, you can put it in a neighboring building. Exclusivity, the magnet store, the anchor store, they are the 2,000-pound gorilla. They get to pretty much sit anywhere they want to. And this is all a matter of bargaining position. As with any circumstance, he who has the better bargaining position is going to dictate the terms of the lease. You may be stuck with some of these. You may have to buy a shopping center with terms you don't like because they're in the leases. But I'm trying to think offhand, the rights of first refusal, exclusivity, rights to a certain portion of the parking lot is something that often comes up. The right to restrict what other stores go in there. Very often you're going to find that you can't put bad commercial stores, tattoo parlors, massage parlors, laundromats. For some reason, people don't like laundromats. I've seen those in various leases where one tenant or another wants to preserve the tone of the shopping center.
Well, and some of this, I think, too, goes back to the verifying the value of the purchase price that you ran into, because so much of these type of deals depend on the rent, depend on the tenants, the longevity of the tenants, the rent that they're paying. So a lot of it is reviewing the terms of these leases, how long some of them are in some of the smaller spaces. Are there personal guarantees? Do they care about that? A lot of these questions can go to, is this thing worth the price that we had planned on paying? Or are we about to lose half the tenants because their leases are expiring? Whatever the case may be. But I would think that's a big part of it.
That's all part of the due diligence. And right, if you're buying a shopping center and the anchor tenant has got 2 years left on their lease, that's a real, and they're not negotiating with somebody to take that space. Number one, you lose a draw to the center. Number two, you've got a lot of empty space to try to rent. And all of this stuff goes into the mix of how you analyze the deal. It's all variable, but that's the nature of the beast.
Yeah. Michael, beyond due diligence, one of the things that can tend to carry things out and take more time than what we might see in a residential transaction are commercial lending requirements and the timing commercial lenders might require. Why don't you talk a little bit about that and what you see?
Well, right. The commercial lender is going to they're going to need as much time as they customarily need for their review, and you're not going to be able to change that. And you should check with your lender first if you've got financing in mind. If they say it takes us 90 days to review a commercial transaction, there's no point putting a 60-day due diligence in your contract. You're going to have to account for that. You're also going to have to account for what the lender wants from you. They will probably want a survey, possibly an ALTA survey. They will definitely want the title work as soon as possible. So you're going to have to arrange for that during the initial due diligence period. They're probably going to also want to see the financial information. They may want to see copies of the leases. And probably they're going to want to take a look at the budget of the shopping center we're talking about, or of the warehouse center, or whatever it is, of the apartment building before they decide whether it's worth it. They're going to make their own cash flow analysis. In most contracts, particularly the ones that talk about keeping the information confidential between the buyer and the seller, the provision usually says except for each party's attorneys, each party's advisors, and lenders, because the lenders are going to require a look at all this information. So I would think that before you start writing the contract, you've got to go to your lender and ask them how much time they need before you start thinking about due diligence periods.
Yeah. Well, Michael, we've barely scratched the surface. I think we need a part 2 of purchase sale agreements to get deeper into the provisions. We really appreciate you taking the time with us to talk through it. Tell our listeners how they can find and connect with you.
Well, my office is in Rockville, Maryland. The website is grossesq.com, grossesq.com. You can get in touch with me there. Ruthless self-promotion here, right? Phone number 301-718-2988. I do answer my own phone. And I would be happy to talk to anybody who would like to talk to me about these matters in the state of Maryland or DC.
Yeah, and Michael does creative finance work as
That's
well
true.
and knows all about that in Maryland and in DC. So appreciate you being on, and let's do it again sometime.
My pleasure. Good to talk to you guys.
All right, you have a good one.
All right.
With that, everybody, that is our show. Make sure to join us next week, and make sure to join us today at 3 p.m. for the Creative Finance Collective. We'll see you next time.
Have a good day, everyone.